Chapter 15, Post-Employment Obligations. So we have finally reached the end of the course. So in this chapter, we'll be looking at explaining a former employee's duty not to disclose or to misuse confidential information. We'll also look at additional post-employment duties of fiduciaries. And fiduciaries are a special type of employee. We'll be defining a little bit later. We'll also be looking at describing the implications of the employee's implied duty to provide a reasonable notice of resignation and the implications of the employee's implied duty to act in good faith, including a management employee's duty to retain employees. So those are the main objectives of chapter 15, and we'll start at looking at the post-employment obligations. In other words, after the employment relationship or the employment contract ends, there may still be some obligations on both general employees and also employees who are considered to be fiduciaries. And I'll define fiduciaries to you just now so we understand who they are. So fiduciaries, initially the definition was very restrictive, meaning it only involved very senior executives. But nowadays, the definition of fiduciaries involves anyone who is vested with power and responsibility to guide and direct the affairs of any organization, any company. So they are mostly officers, CEO, CFO, COO, all the C's available, and also senior employees who have been in the company for quite a long time and have had access to a lot of key information of the company. And also, the definition has been extended to encompass employees that are not so senior but play a key role in the organization. So employees who are, let's say, scientists or key people who have a relevant role in the organization and have some kind of responsibility to either guide or direct the affairs of the company. So those are fiduciaries as well. And those fiduciaries, they owe what is known a fiduciary duty to their employer, both during their employment relationship, but also after leaving the company. But I'll come back to this later. I just wanted to share a brief word on who the fiduciaries are before we started looking at the post-employment obligations. So those obligations, they will apply to fiduciaries and also to general employees. But why are we differentiating them here? Because fiduciaries, they have a bit more responsibilities, a bit more obligations to their employers, also to their former employers. So that's why they are divided here. And one of the main obligations will be related to those restrictive covenants we saw in the past. We saw early in the course, we also reviewed a little bit later. So those restrictive covenants are sections in the employment agreement that may prevent an employee or a former employee from doing something they would naturally be able to do. And the main restrictions are related to confidentiality, so non-disclosure of confidential information, also non-competition, in other words, not competing with their former employer, and non-solicitation, non-solicitation of the former employer's employees, clients, suppliers. So those are the three main restrictions former former employees may have to abide to their former employers. Again, we saw details of those restrictive covenants before, and you may want to remember that the burden of proof that those restrictions are legal, are valid, lies on the employer, on the party that drafted those sections, those clauses. And those clauses, those sections, they are generally valid, legal, as long as they are limited in their geographic reach and also on their time limitation. So remember, we discussed a little bit that it cannot be broad. The limitation cannot be broad. So it cannot be in Canada. It cannot be in the province. It will vary on the position, depending on the position, on the job duties, but it cannot be broad. It has to be as much limited as possible. And it has, the aim will be only to protect the employer's legitimate business interests. It cannot aim at only restricting the former employee's performance or their moving forward to a new company, new job. So let's look into more details on the confidentiality obligation. So again, the aim here is to protect the employer's info and secrets. And the obligation is basically the employee cannot misappropriate confidential information or trade secrets that belong to the former employer, and it will apply during the employment relationship and also after, but after for a limited time, as long as the employer does not need that trade secret or confidential information anymore. And there are some exclusions here. The main one will be related to information that is part of the employee's general expertise and knowledge and experience. So the experience you gain working and the knowledge you gain working, this is not considered confidential information that is protected under the non-disclosure obligation. Okay, but anything that the employer, that the company invested to create, to discover, to make, those will be protected as either confidential information or a trade secret. And the employee's obligation is related to not to misappropriate or to disclose that information. And how do we define confidential information? How do we identify what confidential information is? So, according to the Alberta Court of Appeal, back in 1992, the definition would be if the circumstances are such that any reasonable man, so man was used there in the definition, but here it would be, in modern times, it would be better to have a reasonable person. So, if the circumstances are such that any reasonable person would have realized that the information was being given to them in confidence, then this should suffice to impose upon him the obligation of confidence. And in particular, where the information of commercial value is given with some able common object in mind. Not sure I pronounced this word correctly. Let me check. Okay, so with some avowed common object in mind. So you see here, the definition is quite broad. It's not so specific because, first of all, it has a subjective aspect in terms of confidence. So it was given under confidence. It was given with the knowledge that the person would keep it confidential, and mainly in an employment relationship, mainly when it refers to commercial, when the information has commercial value. So that is a quite broad definition of what confidential information is. I'll share some examples later on, but the conclusion here is that confidential information, the protection of confidential information is very important, very key for employers. So employees should be aware of their obligation and not to misappropriate, to misuse, to disclose confidential information they had access during their employment relationship. There are some tests. Tests here. The test is a legal terminology, so we ask some questions. We assess the information to learn if it is confidential or not. So information would be confidential if it would be injurious to the employer or helpful to their competitors when disclosed. So anyone, an employee, a former employee, in doubt where the confidential, the information they want or they plan to disclose or to use is confidential or not, should be asking themselves if it would be injurious to their former employer or even helpful to their competitor. So if the answer is yes, then it is confidential information. Also, if the information is secret, meaning not in the public domain. Let me give you here two interesting and very famous examples here. KFC sauce and Coke, the Coke syrup. So those are two of the main famous or most famous trade secrets in the world, and they are only valuable because they are kept in secret. The information itself does not belong to their owners. information does not belong to anyone, but because they are kept in secret, they are valuable. So the obligation not to disclose, not to misuse, um, is related to keeping that information secret and valuable. So those two questions or assessments, so injurious to the employer or helpful to competitors and not in the public domain, they must be reasonable, and they also must be judged in the light of the industry that is concerned or trade. And some examples will be computer programs. So for IT companies that develop software, website, apps. So whatever is used and developed within the company is considered confidential information. Any types of lists of suppliers, customers, employees. And again, the information itself uh, does not belong to the employer or to the company, but having it, keeping it as a secret, having those lists, the company invested to establish a relationship with those suppliers, with those customers, hiring employees, etc. So the list, the information that is kept in secret becomes confidential information. Any types of assessments that are created by the company. The same thing for processes, manufacturing processes, analysis processes, any types of processes created by the company. They are examples of confidential information. So now let's look at non-competition and non-solicitation. So it is important to understand that the general rule is that employees or former employees, they do have the right to compete or to solicit without constraint in the employment market, and including soliciting the former employer's clients. And this was set by this case, Alberts versus Mountjoy in Ontario. Um, So it was said that they may do so by establishing a business in direct or partial competition, and they may bring to that business the knowledge and skill which they acquire while in the former service. So that's the general rule. General rule is competition and solicitation, they are allowed. However, there are exceptions to main rules. And the exceptions, they are, well, first of all, not misusing confidential information or trade secrets, as we saw before. So you may compete, you may solicit as long as you acquire the information yourself, or as long as the information is public. The information, you are not competing, not soliciting uh, via the use of confidential information, because that is prohibited. So that's the first lesson here. And another exception would be if the former employee it was and is under a valid restrictive covenant, a valid non-competition clause, a valid non-solicitation clause, and which is most case in employment agreements. So as long as those restrictions are valid, and again, how do we know they are valid? They are valid because they are reasonable in terms of the limitation. What kind of limitation? The geographic limitation and also the time limitation. So as long as they are valid, then the employee who signed that employment agreement, who agreed to be bound by the non-competition and non-solicitation clauses, then they cannot compete. Okay, but again, that's an exception because the general rule is that anyone can compete or solicit. And a key employee, not only the fiduciaries, but any employee who was key to the company, a main scientist, a main developer, um, a main person for that company's services or business, they may owe a fiduciary duty. So a duty that is that has more obligations, as we'll see in a minute, in a way that because they were a key employee, it means they had access to more confidential information, to more key information from the employer, their former employer. So, and they also had a relationship of trust. That's where the fiduciary duty arises. Then their obligations are more strict in terms of non-competition and solicitation. Okay, so those are the exceptions to the main rule that allows anyone to compete or to solicit as to their former employers, business, clients, customers, and employees. So I already explained who the fiduciaries are. So now we look at why the fiduciaries have more obligations than the general employees. So they have more obligations because they were actually key employees to the company. And because they were key employees, they were vested with a high degree of trust and confidence. So in other words, a key employee is not then, because of this, a key employee is not then at liberty to betray the trust they had by soliciting the employer's clients for their own account or for someone else to their indirect benefit. So that comes from the Alberta Court of Appeal. So again, fiduciaries who are key employees because they owe this fiduciary duty. The fiduciary duty comes from this relationship of trust and confidence. Because of this, they cannot solicit, they cannot compete, even if they are not under the restrictive covenants. But that restriction or those restrictions, they come because of their because of the fact they were fiduciaries in the company. Their obligations, their added obligations, they do not exist forever, and the time frame would be a reasonable notice period. So, what a reasonable period uh, will be has to be determined on a case-by-case basis. So it depends on what sector, what industry, what the position of the key employee was, what they did, what kind of information they had access. But the key rationale here is that the trust and the confidence that were given to that employee, they have to be protected. They have to be taken into consideration to protect the former employer's interests. And some other responsibilities for those fiduciaries, for those key employees, are that while in the employment relationship, they cannot quit and then take advantage of a business opportunity that they discover while they were employed, unless they first disclose that opportunity to the employer and give them, the employer, an opportunity to exploit that that opportunity or that business opportunity. Okay, so that's an extra responsibility for a fiduciary. They must also disclose any information that could reasonably impact the business of the employer. So, for example, if they plan to quit or if they plan to start a new business, um, they need to disclose, they have to disclose this to their employer because they are key employees. And as we just saw, they cannot compete or solicit customers for a reasonable period of time after the employment ends. And again, this reasonable period will be assessed on a case-by-case basis. It could be several months, could be a year, could be 2 years. Again, it will not exist forever, but it will be for a reasonable period, a period in which the former employer can recover, can inform their clients, customers that the key employee is not there anymore, and can create the adherence again with their customers without that key employee. So that's the end of chapter 15 and the end of our employment law course. Thank you.